The year is 1991, and the internet has just become available to the public. As this new medium became available, it became necessary to appeal to the compelling interest of protecting children from indecent or obscene material on the internet, as well as maintaining the right to free speech.
Congress's first attempt to make the internet safe for minors was through the Communications Decency Act in 1996. This law made it a crime to distribute online material deemed indecent or patently offensive to minors as measured by community standards.
The act was found to be unconstitutionally vague because it failed to clearly define indecent communications and because the community standards test does not apply to a global medium.
In 1997, the Supreme Court ruled in Reno v. ACLU that the Communications Decency Act was unconstitutional censorship and would prevent protected adult-to-adult communication.
After the Communications Decency Act was deemed unconstitutional, Congress once again tried to regulate internet speech to protect minors. In 1998, the Child Online Protection Act, COPA, was enacted. This law criminalized online commercial distribution of material deemed harmful to minors. The intent of COPA was to prevent minors from purchasing indecent online material rather than trying to prevent minors from merely accessing this material online.
In 2000, the Children's Internet Protection Act, CIPA, was enacted. This law requires internet filters in schools and libraries that receive federal funding for their internet connections.
Ashcroft v. ACLU, the modern application of the Reno case, took place in 2004. In the case, the Supreme Court decided that COPA was unconstitutional because it restricted too much protected speech and was not the least restrictive means to protect children. More on this later.
In 2008, Congress passed the PROTECT Act to combat child pornography.
By 2011, 21 states had internet filtering laws similar to CIPA passed in 2000.
In 2016, 25 states now have internet filtering laws that apply to publicly funded schools or libraries.
Back to 2004, Ashcroft v. ACLU. COPA, enacted in 1998, criminalized online commercial distribution of speech deemed harmful to minors, with the intent of preventing minors from accessing pornography online.
The American Civil Liberties Union, ACLU, sued, arguing that by universally censoring websites, COPA violated free speech.
The Supreme Court concluded, in a 5-4 decision, that COPA restricted too much protected speech. The law used a method that was not the least restrictive available, and COPA could prevent adults from seeing protected adult content and communication, as well as act as a chilling effect for online publishers.
When comparing Reno and Ashcroft, the cases share many similarities but also have some important distinctions.
Both cases address content-based laws enacted to shield children from access to sexually explicit material on the internet.
Both laws rely on community standards to determine whether material is indecent or offensive. If community standards deem that material is offensive and void of any social value, it is no longer protected speech. The issue of addressing or defining community standards is especially difficult within the realm of global internet communication.
Neither of the laws meets strict scrutiny. The laws did not use the least restrictive means to protect children.
Both laws are unconstitutionally overbroad, restricting too much protected speech.
However, these cases also have stark differences. The CDA was more focused on online material that was indecent and patently offensive, whereas COPA targeted the online distribution of harmful material to minors for commercial purposes.
Another difference is that the court suggested another means to protect children in Ashcroft v. ACLU that was not available during Reno v. ACLU: filtering. The court suggested that concerned parents use internet filters. Parental monitoring may be the best scenario because parents can raise their children exactly how they want with minimal government interference.
Filters restrict speech at the receiving end, thus putting responsibility on the audience to filter rather than restricting or blocking the source. This does not prevent adults from accessing protected content. Filters diminish or eliminate the potential chilling effect that would result from enacting COPA.
However, there is a debate about whether filters are effective or the least restrictive method. Washington State is not one of the states that has enacted filtering laws in publicly funded schools and libraries like that of CIPA, but in other states you would have to ask the librarian or technology administrator to turn off the filter in order to search for things like information about anatomy, safe sex practices, or how to do a breast exam. There are potential pros and cons to content-based censorship in public arenas.
It is interesting how the ruling in Reno v. ACLU impacted the court's view of the internet, distinguishing it from broadcast. This view has carried into the modern age with the Ashcroft versus ACLU decision and internet filtering laws.